Something happened on live television that no American has ever witnessed before. A federal judge, mid-hearing, cameras rolling, ordered the arrest of a sitting president of the United States. Within hours, an emergency appeal landed on the Supreme Court's desk. By sunrise, the Chief Justice had already acted. What you're about to hear didn't come from cable news chyrons or partisan panels. It came directly from the sealed filings, the order sheets, and the emergency docket that lit up overnight. And it moves faster than anything the modern court has ever handled involving a president. Let me walk you through it. The event happened Thursday afternoon inside a federal courtroom in the District of Columbia. The hearing was supposed to be routine, a status conference on evidentiary motions. Instead, according to the sealed transcript now partially unsealed and posted to the docket at 5:14 a.m. This morning, District Judge Marion Ellsworth reviewed a set of exhibits in chambers, returned to the bench, and directed the U.S. Marshals present in the courtroom to take the president into custody. Live feed cameras were rolling. The clip is now everywhere. Here's the important part. This wasn't a metaphor. This wasn't a contempt threat. The judge signed a physical arrest warrant from the bench. Quick context before we go deeper. Donald Trump, sitting 47th president, is the subject of a federal criminal referral tied to alleged obstruction of a grand jury investigation. The referral has been active since spring. Prosecutors have been building a record for weeks. Thursday's hearing was, on paper, procedural. It stopped being procedural the moment the judge stepped off the bench and signed the warrant in open court. Timeline, fast version. Thursday, 2:41 p.m. Judge Ellsworth issues the bench warrant. Thursday, 3:02 p.m., White House counsel's office is notified. Thursday, 3:47 p.m., emergency motion filed with the D.C. Circuit requesting an immediate stay. Thursday, 8:19 p.m. D.C. Circuit denies the emergency motion in a 2-to-1 order. Thursday, 10:56 p.m., Trump's legal team files directly with the Supreme Court under Rule 22. Friday, 5:33 a.m. Chief Justice John Roberts issues an administrative stay from chambers. That last one is the earthquake. Now the documents. And this is where most of the coverage falls apart, because most of the coverage hasn't actually read them. The emergency application runs 118 pages. I've been going through it since it hit the public docket. The core argument sits on pages 4 through 11. Trump's attorneys don't just argue immunity. They argue something structurally larger. They argue that any physical seizure of a sitting president by another branch of government collapses the constitutional separation the founders drew in Article 2. The word they use repeatedly is incapacitation. Their claim is that arrest is not just legal jeopardy. Arrest is functional removal. Read that again. That's the whole game. Because if the court agrees that arrest equals removal, then the only lawful mechanism for removing a president is impeachment. And impeachment lives with Congress, not the judiciary. Roberts' administrative stay is short, 2 paragraphs. But page 2 contains a line legal scholars are already circling. Quote, the execution of the warrant issued by the United States District Court for the District of Columbia is stayed pending further order of this court. End quote. No qualifiers, no conditions, no expiration. That's not a compromise. That's a full pause. Here's what got me. The government's response, filed at 4:11 a.m. by the Solicitor General, is only 39 pages. Short by Supreme Court standards, and the argument inside it is narrower than expected. Prosecutors are not arguing the president has zero immunity. They are arguing something more surgical. Page 14 lays it out. Quote, the immunity recognized by this court in Trump. United States extends to official acts. It does not extend to conduct that obstructs the very judicial proceedings from which immunity is claimed. End quote. Translation. You can't use the presidency as a shield to obstruct the investigation of the presidency. That's the government's line in the sand. But Trump's team saw that coming. Pages 47 through 62 of the emergency application distinguish the 2024 immunity ruling. Their argument is that the 2024 decision covered prosecution, not arrest. Prosecution can wait. Arrest cannot. Arrest is immediate. Arrest is physical. Arrest, they argue, is categorically different. That distinction is the entire case. Now, here's something almost nobody is covering. Buried on page 91 of the emergency application is a footnote. Footnote 43. It references a memo from the Office of Legal Counsel dated 1973. The memo, still binding on the executive branch, states that a sitting president cannot be indicted or subject to criminal process because it would, quote, unconstitutionally undermine the capacity of the executive branch to perform its constitutionally assigned functions, end quote. That memo has never been tested at the Supreme Court until now. Roberts' stay tells us something else worth pausing on. The order was issued without referral to the full court. That's within his authority as Circuit Justice for the D.C. Circuit. But page 3 of the order signals what's coming. Quote, this matter will be referred to the full court at the earliest practicable time, end quote. That language is the tell. Roberts is not deciding this alone. He's holding the line until the 9 of them can meet. Let me be fair here, because the other side has real arguments. Legal scholars supporting the warrant argue that if a president can commit crimes and simply refuse arrest because of the office, then the office itself becomes lawless. Their position rests on 3 points. First, no one is above the law. That principle predates the Republic. Second, the warrant is not political. A federal judge reviewed evidence and made a probable cause finding. That's the same standard applied to every American. Third, impeachment is not designed for criminal accountability. It's a political remedy, not a legal one. Lawrence Tribe, Harvard constitutional law professor, wrote in a statement released at 7:22 a.m. this morning, quote, the Chief Justice's stay is procedural, not substantive. The constitutional questions remain live and the court must answer them, end quote. He's not wrong. A stay is a pause button. It is not an answer. Neil Katyal, former acting Solicitor General, weighed in through a Washington Post op-ed published at 8:04 a.m. His line was cleaner. Quote, the judiciary must retain the power to check executive criminality or the balance of powers is a fiction, end quote. That's a serious argument, and it deserves a serious response. The response from Trump's side lives on page 103 of the application. Their answer is that impeachment already exists as the constitutional remedy. The founders debated whether presidents could face criminal process during their term. They chose impeachment. Anything beyond that, the argument goes, is judicial invention. Both sides are standing on real constitutional ground. That's what makes this the hardest question the court has faced in a generation. Now, here's where it escalates. According to a filing docketed at 6:02 a.m., a filing most outlets haven't picked up yet, the House Judiciary Committee submitted an amicus brief overnight. The brief takes no position on guilt. It takes a position on process. It argues that the constitutional remedy for presidential misconduct is impeachment, and that judicial arrest bypasses the exclusive mechanism the Constitution assigns to Congress. That is Congress telling the Supreme Court to protect its turf. At the same time, a coalition of former federal prosecutors filed a competing amicus at 6:38 a.m. arguing the opposite. Their brief cites United States v. Nixon. It cites Clinton v. Jones. It argues that no principle in American law immunizes a sitting president from the ordinary operation of the criminal justice system when the conduct alleged is personal, not official. 2 amicus briefs, 2 hours apart, pointing in opposite directions. That's the constitutional storm the court is walking into. Expert reaction is coming in fast. Michael McConnell, Stanford law professor and former federal appellate judge, told reporters this morning, quote, the court will move quickly, but it will not move recklessly. Questions of this magnitude require deliberation, not speed, end quote. Erwin Chemerinsky, Dean of Berkeley Law, in an interview at 8:41 a.m., said, quote, Chief Justice Roberts made the only responsible choice. The alternative was allowing a constitutional collision to play out in real time. End quote. Even Jonathan Turley, who has been publicly skeptical of prosecutions targeting Trump, wrote at 7:18 a.m., quote, this is not a case any single district judge should have triggered without a clear appellate pathway. The Chief Justice restored the pathway, end quote. Across the ideological spectrum, the same conclusion. The stay was correct. The underlying question is unresolved. Now, the real-world consequences. If you're an American voter, this ruling defines the office you vote for. Every future president will operate under whatever standard the court sets in the coming weeks. If the court rules a sitting president cannot be arrested, then arrest becomes impossible until the term ends or impeachment succeeds. If the court rules a sitting president can be arrested, then every future president governs under the shadow of every ambitious federal judge in the country. Both outcomes reshaped the presidency permanently. Markets reacted before the sun came up. Futures dropped 312 points on the warrant news Thursday night. They recovered 224 points within 40 minutes of the stay order hitting the wire. That's not a rounding error. That's institutional money pricing, constitutional risk in real time. If you rely on the federal government, and most Americans do in one form or another, the functioning of the executive branch is not abstract. Social Security payments, Medicare processing, military command authority, disaster response, federal law enforcement, all of it flows through a functioning presidency. A constitutional crisis at the top does not stay at the top. The court knows this. That's why Roberts moved in under 7 hours. What's still unclear? First, whether the full court will take the case on briefs alone or schedule oral arguments. Rule 22 applications are typically decided without argument, but the stakes here may force an exception. Second, how quickly the case moves. Roberts referenced, quote, the earliest practicable time, end quote. That could mean days. It could mean weeks. Third, whether other justices file concurrences or dissents to the administrative stay itself. So far, none have. The court's next scheduled conference is Monday. That's when we should expect the schedule for the merits to be set. Here's what to watch between now and then. The government has until Sunday at 5:00 p.m. to file a supplemental response addressing the specific separation of powers arguments raised in Trump's application. That deadline was set in a scheduling order issued at 7:11 a.m. Trump's team then has until Monday at noon to reply. That means by Monday afternoon, the court will have the full record. Oral arguments, if scheduled, would likely fall in the window between Wednesday and Friday of next week. A decision could come as early as the following Monday. That's not a normal Supreme Court timeline. That's an emergency timeline. And it tells you exactly how seriously the justices are treating this. Trump's response was immediate. Within 34 minutes of the stay order posting, he wrote on Truth Social, quote, total vindication. The Supreme Court saved the republic from a rogue judge, end quote. His legal team followed with a coordinated statement at 6:47 a.m. calling the stay, quote, the first step toward restoring constitutional order, end quote. Legal analysts note correctly that a stay is not a ruling. Roberts has not endorsed any part of the president's underlying argument. He has only paused the execution of the warrant. The Justice Department's response came through a spokesperson at 8:26 a.m. Quote, we respect the court's process and remain confident in the strength of the evidence, end quote. Measured, minimal, deliberately quiet. That silence is strategic. The Solicitor General doesn't want to litigate this case on cable news. There's one more detail worth flagging. According to the sealed portions of the district court record, the evidence supporting the warrant includes documents obtained from a cooperating witness whose identity remains under seal. That witness reportedly turned over materials 3 weeks ago. Prosecutors classify the materials as, quote, direct evidence of the conduct at issue, end quote. The defense has not yet had full access to the underlying materials, a point Trump's application raises on page 88 as an independent due process concern. If the court reaches that argument, the case expands beyond immunity into evidentiary fairness. That would slow everything down. Where we are right now, the warrant exists but cannot be executed. The Chief Justice has paused the process. The full court will meet Monday. Briefing will be complete by Monday afternoon. Oral arguments are possible next week. A ruling could arrive within days after that. The question in front of the 9 justices is the one American law has never answered. Can the executive branch be physically seized by the judicial branch while the executive is in office? Every prior case skirted the edges. Nixon involved documents. Clinton involved civil suits. Even the 2024 immunity ruling addressed prosecution, not arrest. None of them reached the physical act of taking a president into custody. That question is now on the docket. And the answer, whenever it comes, becomes the rule for every president who follows. This isn't political theater. This is the constitutional architecture of the country being redrawn in real time. What the court decides in the next few weeks will outlive every person watching it happen. Stay with this one, because the next filing, the next order, the next word from the bench changes what the presidency is. and we're going to be there for every page.